We're going to kick things off. Hello, everybody. My name is Laura Ryan, and I'd like to welcome you to today's webinar. I'm a partner in the employee benefits practice of Thompson Hine, and I'm joined today by Tim Brown, also a partner in our employee benefits practice. Today, Tim and I will kick off our webinar series, our retirement webinar series, by reviewing compliance and risk mitigation best practices that fiduciaries should consider implementing as part of a prudent fiduciary process. This webinar is the first in a series of 4 webinars that we will be presenting the second Wednesday of every month at noon Eastern through the end of the year. Each webinar will explore a different retirement-related topic, including ERISA litigation, retirement plan investments, and legislative updates. You can register through the invitation you received or on the events tab on the Thompson Hine website. To address up front a question that we frequently receive, today's webinar is being recorded, and the recording will be sent to everybody who registered for the webinar within approximately 48 hours of the program. That email will also contain the slide deck from today's presentation. During today's presentation, please feel free to use the question panel in the upper right-hand corner of your screen. I will be monitoring that, and we'll try to address your questions as we go through the material or at the end of the program, or if we get a lot of questions and don't get through them all, we'll follow up after the program. So with that, let's begin today's program. Tim is going to kick us off with Fiduciary Committee best practices.
Thank you, Laura, and welcome, and thanks everyone for joining. We'll hopefully make this pretty informative for you, so you can take back some of these best practices and apply them in your own situations. But what I want to start out with is really talk quickly about what is the origin and source of all these fiduciary duties, requirements, and best practices. And it really comes back to the basics of the employee of ERISA. ERISA standing for the Employee Retirement Income Security Act of 1974. And a little trivia, President Ford signed that into law in 1974. So one of the things you can remember or thank President Ford for at this point. But it's been around for a while, and it's evolved through regulations in a lot of federal court cases to interpret ERISA as we are today. And it is continuing to evolve fairly rapidly, as we will talk about. But is ERISA, what ERISA really does, it covers a broad base. It regulates all employee benefit plans. That's with respect to welfare plans, 401k pension plans, and some of your fringe benefit programs. It's intended to protect participants and beneficiaries. We'll get into how that works. It does require all this disclosure and reporting. All the notices that you send out are almost all sourced from ERISA or the Internal Revenue Code. And the reporting, your 5500s and audits and all those other requirements come from the ERISA requirements. It tries to provide uniformity in administration of plans to try to make one federal law that governs benefit plans instead of having a 50-state patchwork, which you have in other areas, but not here in the employee benefits arena. And the most important, it establishes these high standards of conduct and obligation for fiduciaries. And in order to enforce that, it provides for access to an exclusive, almost exclusive jurisdiction with the federal courts for that. So that kind of gives you a background of where does all this come from? It comes from ERISA. But then you have to ask yourself, well, who are these fiduciaries? The fiduciaries, the people responsible for the management and maintenance and making decisions under a plan. I'm going to really focus here more like on 401k plans here, although a lot of this is applicable to pension plans. I think the focus and hot item of right now is really the 401k context. But you really need to look at who is your plan administrator, and normally your plan documents say that the plan administrator is the named fiduciary, or it would designate some other individual or some other committee. If it's silent, it says plan administrator is the company, well then probably the board or whatever operating governing body of the company would be the fiduciary. Something to be mindful of as we get to the next couple of slides. Most larger plans, as companies get larger and plans get larger, they have a more formal committee. I use the generic term benefits committee here, but their terminology could be 401k committee, investment committee. In the pension side, they call them PICs, pension investment committee. But whatever it may be, it's a committee appointed by the company and board to take on all these fiduciary responsibilities and to set forth what we're going to talk about as far as best practices for a committee. If your company's set up with a board and the board has delegated responsibilities to an individual or a committee, the board still has fiduciary liability, however limited, because they have a duty to monitor, appoint the members, remove members in most instances, and to monitor the committee. So the board is not completely off the hook when it comes to delegating fiduciary responsibility to a committee or other individuals. Okay? And then the other fiduciaries coming up are those who manage your plan assets, trustees, investment managers, and your independent advisors. So that kind of sets the stage of who's really in this world of fiduciary responsibility. Then we jump over to, okay, we've got ERISA. ERISA requires us to do all these things for fiduciaries. We know who our fiduciaries are. Okay, let's get to the broad base. What are our ERISA fiduciary duties? Well, these are the kind of the 5 key ones that you'll hear and you see constantly when people are talking about ERISA. The fiduciary of the plan, whoever it may be, the committee, which I'll focus here going forward, just assuming a committee, but if it's an individual, you replace it with committee. You must be loyal, act for the exclusive benefit of your participants and beneficiaries, like what is in their best interest, not what's in the company's best interest. And many times, okay, you got to diversify your investments. You got to follow your plan documents, which we'll get to some examples. You need to comply with all of your ERISA and IRS requirements. And you can't deal with these assets on your own account or get kickbacks or other compensation for dealing with these plan assets. So it's a pure fiduciary, independent responsibility and duty to the 401k plan in this instance. Okay. Now we get into, well, what's ERISA say about these fiduciary duties? What do you need to do? The broad base, what DOL has told us to date, is that these fiduciaries, the committee, needs to have a prudent process for selecting investments and service providers, ensure that fees that are paid to the service providers and record keepers and others are reasonable. They need to select investments that are prudent and diversified, and they need to monitor. So I think the key takeaways, which you're going to see in my 10 best committee practices that we're going to get to in a couple slides, are the focus here is process, have reasonable, prudent, and monitor. So all those are key themes that you need to think about as a fiduciary. Do we have a process? Are we following it? Are we looking at the fees to make sure reasonable? Are we prudent on our investment selections and monitor? And do we monitor? Do we have a process? Okay, and we're going to go into more details on how you satisfy these requirements. And the reason why, I think if we were talking about this 10 years ago, we probably wouldn't have this slide up, fiduciary litigation. There was not much fiduciary litigation out there except for some more egregious type matters. But as time has gone on, 401k plans have become more popular, assets have grown significantly, and you've got plaintiff lawyers now looking for other causes of action. They have stumbled upon, purposefully or not, 401k plans as a new source of litigation. Understanding that hundreds, I don't know, it could be over 200 or 300 cases have been filed since the beginning of 2020. That's in 2 years. You have several hundred cases being filed against 401k plan sponsors regarding their 401k plans. So that's what is really bringing this to the forefront of the last few years, is the significant increase in litigation and significant need to have a good fiduciary process in place to avoid, to the extent that you can, any litigation that could come down the road at you. We have new complaints, filed not every month, it's almost every day. We look at our updates and there's a new lawsuit filed almost every day. We have plan sponsors that are across all industries. There's just not one industry being tagged here. It's across. Anybody has a 401k plan is a target. The larger you are, the more of a target you may be. However, what's happening is the plaintiff lawyers are coming down in size. I just pulled a lawsuit that was filed last week. It was against a company in Colorado. It had $200 million of plan assets, and they're being sued for your typical allegations of high fees, expensive funds, poor performing funds, and having an insufficient fiduciary process. So that's now starting to come up in these cases where plaintiff lawyers are really saying to the court, They don't have a process. It's insufficient, because if they had one, we wouldn't be here talking about and suing them over high fees, badly performing funds, or expensive funds of this type. So this area is evolving rapidly. We'll probably continue to see lawsuits until we see either legislation coming out of Congress, which is probably not happening in the near future because of what's going on in Congress today, or the federal courts come to some agreement or gets back to the Supreme Court about level setting these types of lawsuits and having higher pleading standards before they can file a lawsuit. So until that happens, the best practices are, I think I'm going to go through the 10 best practices that you should be looking at and you should be thinking about implementing. We go to the next slide. Okay.
Yeah,
So this is,
Tim, before we go there, I just want to emphasize, you mentioned evolving. And, you know, certainly if you have never put in place a process, you know, you're going to learn quickly the type of process that you should be putting in place. But because of the evolution of the case law, I think even if you have a process and, you know, it checked the boxes, let's say 5 years ago, but you haven't really, you know, refreshed or updated that process, there's probably opportunities to add things to the process, to, you know, revisit the way in which you record minutes from meetings. That has evolved. And all of this is because of the evolution of the litigation in the case law. We see, you know, the allegations and the theories. And so we want to, you know, add or improve our process to help, you know, head off those types of theories and allegations.
no, thank you, Laura. And I think this is where you need to have a good formal documented process that what I'm about to, you know, kind of go through these 12 best practices from the checklist so that you have a written record to show. So I think if you go through these best practices, it's going to give you, I think, a very high level of comfort of avoiding lawsuits. It may not be 100% proof, but if a lawsuit does come up, you're going to have a good administrative fiduciary record to show you've done all the things that you need to do. And the way the federal courts work here is that you don't have to have the lowest fund, the lowest fees in the market. You don't have to have the best performing funds. But what you do need to have is a set of funds and fees that are reasonable based on a process that shows that you've gone through and shown they're reasonable with benchmarking and looking at the market. So you don't want to have the highest fees. Obviously, you don't have to have the worst performing funds. So you're not always chasing the lowest fee or always chasing the best funds. You just need to make sure that the funds you have, the fees you're paying, are reasonable based on a lot of facts and circumstances, including industry averages and benchmarking. Okay, so we get into the checklist. Let's jump right in. Okay, I talk about committee. So if you don't already have a formal committee, it might be informal or it might be an individual or could be nothing. I think the first thing to do is establish a committee, fiduciary committee, and name it what you want to name it. I'll call it the 401k investment committee. The best practice is to meet quarterly, have a written charter or delegations, and have written agendas, and then making sure you have written minutes from those meetings. There is a line of federal court cases that say if it's not documented by a fiduciary, it didn't happen. So you need to make sure that however this process goes, that you are well documenting that you have a committee, it's documented, you have a charter, and we have, I think investment consultants and attorneys, we have some really good, fully loaded charters that have all the fiduciary requirements and responsibilities in there. Investment advisors and people like us, we have standard agendas we like to see and use for good fiduciary practices. So you need to make sure that if you have a committee, if you don't have a committee, you should set one up. If you do have a committee, make sure you have good updated delegations, charters, agendas, and minutes, and that you're meeting quarterly. Okay. When you meet quarterly, you want to make sure that you have an independent investment advisor to work with you. And then investment advisor, many of you probably already have independent investment advisors. There's many out there. There's many good ones out there that do have good quarterly review processes, decks, materials that they would then use with the committee to go through and monitor the investment performance and fees on a quarterly basis. Also, there's certain items that you may not want to do quarterly, but you should be looking at annually, like the record keeper fees, kind of benchmarking them annually, looking at your investment policy statement, which I'll get to, looking at your managed account, your target date funds, your brokerage windows, your cybersecurity processes, your communications, your education program. All of those things should be addressed and dealt with at least once a year by the committee. So when the committee meets, you have a core agenda of looking at the investment performance and fees for that quarter, but also they should be looking at some of these certain items each quarter, and some items each year. So I think it's very, very important to use and have an independent investment advisor to be working with the committee hand in hand when they do these quarterly reviews and updates. Okay. The third item there is establish and follow an investment policy. You really need an investment policy, and most of your investment advisors will help you and assist you in putting that in place and reviewing that annually. And it really lists out what processes the committee follows and uses to evaluate the funds and fees. It'll put in your benchmarks. It'll say you're doing this quarterly. It'll have a process for reviewing funds that don't meet the benchmarks, and at what time and when is it appropriate to remove those funds. So it's a good guidelines. And if you have an investment policy statement, you should follow it, because one of the things the plaintiff lawyers like to do is get a hold of a policy and then show that you're not following it, which would not go well when you're in court, not following your own fiduciary processes that you put in place. So I think it's important to have a policy, work with your investment advisor to update that and review it annually, and make sure you're following it and give yourself some flexibility. Okay. Looking to the fourth item, and this has become a real hot button here in the last couple of years, is conduct an RFP, or what some people call an RFI, request for information, on all the services being paid by the plan. And the focus here is on your record keepers and record keeper fees. So if you have not done an RFP, RFI within the last 3 to 4 years, 5 years is a stretch, depending on how big your plan is. The bigger the plan, the more I'd go to 3 years. The smaller the plan, you could stretch it to 5. But you should be working with your investment advisor or consultant to kind of go out during this 3 to 5 year period and look at the fees that would be charged by other providers to your plan. It doesn't mean you need to switch. Whatever provider you're using today, whether it's Vanguard, Fidelity, Schwab, T. Rowe Price, whoever you may be using, that's fine, and you're happy with them, you think you have a good fee, you still need to go out and test the market and look at other providers and other fees that they would give you. And you need to take that look at that process, and if you end up staying where you are, that's fine. You just need to have that review done and a reason why you're staying where you are, because where you are, you have good fees. If the other providers may charge a couple dollars less, but it may not be worth moving for a couple dollars less, but you need to go through that process and make that determination and make sure you have that in your fiduciary record. Okay. The other is looking at and making sure you have the lowest share cost available of that investment class or that investment vehicle. Share classes, as the plans continue to grow, although that may not be going on right now, but pre this year, hopefully assets will be coming back. You need to continue to monitor each quarter when the next lowest share class of that type of fund that you're in would be available. And when it becomes available, you need to give serious consideration to moving in that fund. Also, part of this is what they call revenue sharing or revenue rebating. And investment managers, your investment advisors should be looking at share classes with revenue sharing, because if you have a higher share class with revenue sharing and that revenue gets rebated back to participants, it could be net the lowest share class available. So it's something also to make sure you're looking at and asking, are there share classes available that have revenue sharing that would be even lower than what you currently have? And then as plans get larger, 100 million or maybe above, there could be collective investment trust. That's a SIT. Those are even less expensive than mutual funds, but very similar in structure. So something to at least keep on the radar to make sure these questions are being asked. Okay. One thing I just mentioned is document the meetings and decisions with detail to demonstrate that you have gone through and have done your process. And this is where Laura alerted to is making sure you have some pretty good detailed minutes. You don't want them too detailed, you don't want them too thin, but you want the minutes to reflect that you have reviewed certain things, you've given consideration, and you concluded it's reasonable, your performance, your fees, and other decisions that you're making. So that I think it's good to have good minutes, and some of the independent investment advisors do that for you, and they do a good job at that. So I would, leverage them to help you, or leverage counsel to be able to help you make sure you're drafting these quarterly minutes as you go along.
Hey, Tim, before we move to the next slide, wondering if you could comment on a question that came through asking if a fiduciary has to go through the expense of an RFP every 3 to 5 years, or can a robust independent benchmarking study suffice? Wondering if you can comment on that.
Yeah, my opinion, no, because benchmarking doesn't go out with your specific plan demographics and other data and information, because what you're going to be giving to other vendors in an RFP, RFI is the size of your plan, your average account balance, your number of participants, your investments and things of that nature. So it's more specific and tailored. So RFP, RFIs are comparing apples to apples. If you're going benchmarking, that's complete. Those are just averages. It's not getting exactly to what the market would pay, or the market would charge your plan, the market being other competitors within the space. So my advice is no. Benchmarking, I think, is good to do every year, just to make sure your fees every year are not fluctuating too much based on asset flow or market adjustments. But I think you definitely need a more detailed, robust RFP, RFI every 3, 4, or 5 years. Okay. Now the next item is conduct a detailed review of your target date funds every year. And this is one of when I went back and talked about having quarterly meetings, but then having certain topics reviewed and discussed once a year. This target date fund is one that you'd want to review and discuss once a year. And your investment advisor should have some good materials and programs to really peel back the target date fund that you have to make sure it's performing in accordance with industry benchmarks. You understand if it's a 2 or 3 type of target date fund, what the fees are, and how that target date fund compares to other target date funds in the market, especially if you have an active target date fund or in a passive index target date fund. You should be comparing it to the performance of other target date funds in that category, as well as fees, to make sure what you have is reasonable and it's not out of line with industry averages or benchmarks from that end. This target date fund has been another big hot button of litigation, and there's been many lawsuits filed against active target date funds, plan sponsors over their active target date funds, saying that their target date funds are poor performing or have higher fees versus other available target date funds in the market. So you need to be very careful with when you review these, document your review, and hopefully what you have comes out to be reasonable based on all the information, the benchmarks, and the comparisons. And also these same plaintiff lawyers are now suing plan sponsors over their passive or index target date funds, saying you just can't go down to these lower single basis point passive target date funds and not look at the performance. So they're now going after, I think a lot of big companies have been sued over the last month, probably 9, maybe 10, over their passive index target date funds. And we as an industry thought that would be a safe haven. How could you get any lower fees than passive? But they're not arguing over the fees, they're arguing over the performance of the passive index funds. Okay? And you've got big names out there that have just been sued by this same plaintiff law firm that's suing plan sponsors with active target date funds, including big names, Marsh McLennan, which is the parent of Mercer, Microsoft, Citigroup, Capital One, Black & Decker, Genworth, Cisco Systems. So they are targeting the bigger plans at this point, but there's no reason why they wouldn't at some point be targeting smaller plans as they move down. So that's just something that if you have not done, something you should consider looking at in depth, your target date funds, and making sure they're lined up and doing the appropriate review. Okay. The next item is reviewing your managed account service provider, and make at least once a year, making sure that the fees being charged by this managed account service are reasonable based on market pricing and data and benchmarks, and looking at who's using them, the utilization, and make sure it's working for your participants. There's been several lawsuits over managed account fees being high and the managed account returns not matching the returns of such as a target date fund. So the plaintiff lawyers are coming in saying you have this managed account service, you have 100 participants in it. Not only are they paying high fees, they're not getting a good value because they could have just gone to the target date funds, which would perform better for them. I think they're comparing apples to oranges, but that's the argument that they're making. This is also, people may have heard of financial engines. This is the same type of managed account. Every vendor calls it something different, but I think almost every large 401k vendor has a quote managed account type of service. And for those of you not familiar with managed account, that's where you, for a fee of 40 to 60 basis points, give or take, where they would have investment professionals basically take over the investment of your account and invest it in, based on your information, demographics, risk tolerance, would then allocate it among the investment funds available in the plan and actively manage that for you in the account for, again, exchange for a fee being charged. So that's something else that it's now a new hot button. So if you have managed account, financial engines, you need to make sure you do a thorough review of that at least once a year. Okay. Same thing with brokerage windows. That's also is a hot item that a lot of plan sponsors have put in brokerage windows. I think they could be a good thing in a plan if structured the correct way. But you also need to, if you have a brokerage window, at least once a year, you need to have with your investment advisor or investment consultant, take a look at the brokerage window, seeing what is the usage, what kind of funds are being made available, what's the activity within the fund, and just making sure that there's no frequent trading or other issues that could come up with respect to the brokerage window. Now, it's been a big debate out there whether or not planned fiduciary should be looking at the 6,000 funds offered under a brokerage window. I think not, but it's a very unsettled area when it comes to brokerage windows. The DOL has not issued any guidance or very little guidance on brokerage window, but the best practice we think is to make sure at least once a year, you just take a look at it, see who's in it, how much is in there, how much activity, what they're invested in, and make sure that there's nothing in that 6,000 funds or how many being offered are not going to cause any fiduciary issues, such as cryptocurrency. I think a lot of the brokerage platforms do not have cryptocurrency in it. And if there is, a strong suggestion would be is to make sure it's not included or it's excluded. So it's things that of that nature that you need to make sure that you're kind of looking under the hood of the brokerage window and not just ignoring it. Okay. Last three items, we're rounding third here. You need to monitor significant high-profile regulatory actions against service providers, whether that's your 401k record keeper or the mutual funds that may be out there, because in the past there have been issues with mutual funds regarding accounting issues or the fund manager leaving that could cause issues that you need to monitor and have a highlight. But your investment advisor should be bringing those to your attention quarterly if there are any. If for those plans that have company stock out there, I think there are still plans that offer their own company stock, which I think is it's been a more favorable environment now since a recent Supreme Court case that I think has set some pretty high standards for any lawsuits over company stock funds. I think that would happen about 5 years ago. So company stock funds, I think, are coming back here slightly. Companies that have them, I think, need to make sure that you're monitoring the stock fund just like you would any other fund. And our advice would be is to engage an independent expert or a fiduciary to monitor and review that fund on a quarterly basis. And that really is based on this recent Supreme Court decision when it comes to fiduciary duties, responsibilities on holding a company stock, offering a company stock fund. We could spend an hour talking about company stock funds and the need for an independent fiduciary, but if you have a stock fund, I think a takeaway would be is if you don't already have an independent fiduciary reviewing it, it's something to consider or discuss. Okay. The last item is, as we know, under some of the new fiduciary rules and standards, a lot of the 401k vendors are giving distribution advice to participants who call up and they want to find out whether they should take a lump sum, do a rollover, how they should take their distribution. Many of these vendors do offer that service and provide that advice. As a fiduciary, a plan sponsor, you need to make sure you're monitoring that, and this is something you would do once a year, is get a report from your record keeper with respect to all of the interactions that they've had, and they should be able to provide this fairly easily with participants regarding distribution advice. And based on that advice, where did the participant, what action did the participant take? Did they stay in the plan? Did they take a lump sum? Did they roll it over? And if they rolled it over, here's the key issue, did they roll it over to your 401k record keeper's IRA? And I think that the issue here is making sure your 401k record keeper isn't steering your participants' distributions to their own IRAs. As you know, people know IRAs would then go into more a retail type of product, and a retail share classes and likely more expensive share classes or mutual funds than you would get if they stayed in their plan, your plan, or rolled it over to another employer's plan. So that's kind of the key fiduciary issue there. But that's something you should be doing again once a year, is reviewing that advice and making sure there are no issues. With that, I think I bring it to.
We've got a couple questions related to, before we move to the next topic, I want to throw this out to you, which is the independent investment advisor, which I think was best practice number 2 or 3 on our list. And question is kind of, what are the best practices for selecting and evaluating on a go-forward basis the investment advisor? And specifically 2 questions on that. One is, what if the record keeper offers investment advisory or consulting services? Is it okay to use, the record keeper's services? And 2, how often do we think you should be conducting an RFP for investment advisory services to, check both the services but also the fees that are being charged for those?
Good questions. I think the key is independent. So in my opinion, using the investment advisor provided by the 401k administrator or vendor is not independent. It's good to have their input, but they're not independent from that end. So I think it's better and best practice to have someone that's truly not related to your 401k provider or 401k vendor. So that's first. Second is, I would look at, in my opinion, there's not as much scrutiny on independent investment advisors as there are on your 401k record keeping fees. So my recommendation has always been every 4 to 5 years, maybe 5 years, take a look at your independent investment advisor and think about whether it's appropriate in the time to go out and look at other advisors, just to make sure what you're getting is what you want and what the market is providing, and making sure that your fees being paid. Now, if the company's paying the fees, that's maybe give you a little more flexibility. But if you're charging participants or using forfeitures from your plan to pay the independent investment advisor, you're using plan assets there, and then you should be, having definitely going out every 4 or 5 years and just looking at a few other investment advisors, getting an RFP from them, and then just comparing the services to what you're getting now and comparing the fees, and just making sure you are getting what the market is offering. And you might be surprised what you may find, what other providers may have that do differently, and give you some ideas or thoughts, or may incentivize you to potentially move to that other investment advisor. Did I cover the 2 questions, Laura?
Yep, thank you. All right, let's move now to the topic of missing participants. This is inclusive of a sister topic, which is uncashed checks. This issue, I'm just going to probably call it missing participants for short, is kind of an emerging or an evolving issue. It really came on the Department of Labor's radar 3 or 4 years ago. We started to see and hear that the Department of Labor was really focused on this topic, and it was coming up in the context of audits of defined benefit pension plans. But it has definitely sort of blossomed and is now really a focus also as it relates to 401k plans. And the expectation both, and the IRS is also, concerned about this issue, but I'd say it's more so the Department of Labor, and their expectation is that of planned fiduciaries is that you're not solely relying on the record keeper to monitor this issue and to solve this problem. There is an expectation on the part of the regulators that employers, plan sponsors are, in addition, taking their own, taking its own action to, first of all, monitor the situation. How many people are out there that are in our plan for which we think we don't have good current contact information for, either because we keep sending notices and they keep getting returned, or we keep sending emails and they keep bouncing back, and or how many uncashed checks do we have sitting out there? And if this is something that you have not paid close attention to, or any attention to, you might be quite shocked at the number of participants in your plan that are included on a list of missing participants or lost shareholders. Kind of each record keeper has a different name that they use for this report, as well as the number of uncashed checks, and further shocked at the amount of those uncashed checks. It's baffling that people can have, a $50,000 check that's been sitting out there for 6 months, a year, more. But it's there, or it could be there. I've seen it. So this is definitely, a newer hot topic. And if it's something that isn't on your radar, it should be. I will also say that beyond the fact that this is something that is on the regulator's radar, and is certainly, 100% going to be a topic that they're going to review if they commence an audit of your plan, either the DOL or the IRS. It's an issue to be concerned about for other reasons as well. And those reasons include the fact that if you don't have good contact information for participants in your plan, whether that's a mailing address or an email address, that means that certain required notices are not getting to those individuals. And many of those required notices are designed to provide the plan sponsors and plan fiduciaries with protections, right? If you provide participants with an annual qualified default investment alternative notice, QDIA notice, and tell each participant, if you don't, direct your investments elsewhere, they're going to be defaulted to the X target date fund, and you've given that notice, then you're protected when those default investments happen. There's protection built into the fact that you're on an annual basis providing a fee disclosure notice to participants. If that's not getting to the participants, that can result in liability to the plan. The other consequence of having people that can't be located is you start to run into issues when it comes time to require a commencement of distributions or a payment of benefits from a plan. So, hopefully you're all generally familiar with the fact that qualified retirement plans are subject to certain minimum required distribution rules, which require that distributions be made or at least commence in a certain minimum amount once an individual has attained a certain age. The old rule used to be 70 and a half was the age. Under a new rule is impacted by the Secure Act, that age has moved to age 72. There are also specific rules about when beneficiaries must receive, the latest date by which they must be paid out of a plan. And those vary based on whether the beneficiary is a spouse or some other individual or an entity. But again, these are qualified plan rules that the plan must comply with, and compliance becomes very difficult if you can't find someone in order to make that distribution. And then that becomes a focus of the regulators in the context of an audit. You know, one additional final comment I'll make before we kind of talk a little bit about the checklist of things that you should consider doing around this issue. I'm sure something that's coming to your mind is, well, wait a minute. Why is this our responsibility to keep track of people when they move, when they change their email address? Isn't that the participant's responsibility? You know, after all, they're the ones that know, you know, when they've moved or when they have updated their email address. And I'm completely sympathetic to that thought. And, you know, it makes perfect logical sense, but I'm here to tell you that is not at all the way the Department of Labor views this. You know, right or wrong, or fair or not fair, the DOL really sort of has this high expectation that it is the employer, plan sponsor, fiduciary that has the responsibility to, you know, keep track of folks and to take whatever effort is needed to you know, find current contact information for participants and or for beneficiaries. And to that point, we wanted to share with you an actual email that an employer received from the Department of Labor. This was in connection with a defined benefit pension plan, but we have seen similar, but you know, slightly different requests associated with 401k plans. A couple of things before we focus on the substance of this. Just, you know, the date is the actual date, so, you know, it's no lie that this is a very, you know, current topic. An email was sent, you know, just a few months ago. Kind of at the very bottom of this email, if you notice, they're given 10 days, 10 business days to provide the information. Now, you know, it's not uncommon to be able to negotiate an extension, but, you know, the extension is not lengthy. You know, if we get double the time, 20 business days, that still can be a very tight turnaround, especially if you have not already sort of proactively addressed this missing participant issue. You know, again, some of these requests are very specific to a defined benefit pension plan, but I call your attention to the third bulleted item, which really applies to both types of plans. What is the procedure when a participant cannot be found? What steps does the plan take in order to ensure the participant begins receiving his or her benefit? So with that, what are specifically the things that you should consider doing to address this issue, to be prepared in the event you receive a request from the Department of Labor regarding the plan's missing participants or uncashed checks? Kind of in no particular order, one thing you should be doing is making sure that on, you know, most, if not all, participant communications, that there's a clear and upfront statement regarding the importance of keeping the plan, you know, up to date with changes in contact information, and a very clear instruction on how participants do that. And I know that in some cases there are different processes depending on whether the participant is an active employee versus a former employee. And, you know, this messaging should be very clear. You know, it's not uncommon that if they're an active employee and they have a change in address, they should be contacting the employer and updating the records on that end, and then that information will feed to the plan. And if they're a former employee, that they are to call the record keeper of the plan in order to update their address. But whatever your procedure is, it should be clear. You should also, as I mentioned, ask for a report from your record keeper of anyone that they may have flagged as missing. And this hopefully would include anybody whose mail has been returned as undeliverable, for example. Hopefully a record keeper is tracking that and is able to, provide a report with this list, or anybody who was sent an email that was that bounced back. And in addition, an uncashed check report. And this isn't, unfortunately, this is not a task where you do this once, you get all caught up and you understand what the situation is, and you whittle the list down to the smallest number. But this has to be, part of a regular process, because, all the time, right, people are changing their contact information and not, or being sent checks and, not cashing those checks. So, item number 2 is just getting familiar with how big of a problem is this for our plan right now. And then you can begin to think about the steps to be taken to sort of fix or reduce the problem. The third item is to, and that's where we go to next, identify processes that are already being followed by the record keeper, plan service provider, to locate missing participants. By now, many record keepers have developed a process that they follow whenever mail is returned. And there may also be enhanced services for a fee, extra services or efforts that can be made that the service provider offers to help locate missing participants. So, ask and understand what are the standard processes, ask and understand whether there are, enhanced services that could be considered. And then, the fourth item on this list is, are there other services, third-party services, outside of our record keeper that are available? And I will say there are. I mean, there are a number of good search firms out there. Many of them have been doing this for many years that have a very robust, process that involves checking lots of different public records databases to try to find those that are particularly difficult to track down. And all of this has to be, weighed in the context of, how many people are on your missing participant list, what is the cost to, engage any of these services. You look at it in the context of, and we're going to get to this, you may think about a person with $1 million account balance a little different than somebody that has $10 in the plan. Arguably, higher effort should be made to find the $1 million person than the $10 person. You want to be sure you're checking your own records, and this is really the step that I think some people miss. They are sort of 100% relying on the record keeper and their steps and the information they're able to access, but you really need to go back and make sure you're checking your own records, and that could be even records of other plans that you maintain. If you have a pension plan in addition to a 401k plan. Etc. Really important is adopting a written policy that sets forth, the steps that you are taking to stay on top of this issue. It goes back to something that Tim said as part of his comments, which is, if it's not written down, you're not doing it or it's not happening. So, almost kind of a self-serving policy that really, documents all of the steps and the work and the requests that you've made in an effort to try to, get on top of this issue for your plan. Address active employees immediately. This may sound ridiculous, but, when you get that list of missing participants, there's almost always a subset of people on there that are active. And I don't exactly know how this happens, but somehow there's, a disconnect between, the address in the employer's records and the address at the record keeper. But if you think about it, if you're giving them a paycheck and sending them a W-2, you should have a current mailing address for those individuals. So those are kind of low-hanging fruit. And then the final thing is to prioritize the uncashed checks. I think is also should be top priority. Because it's the top priority of the Department of Labor. They don't like to see those uncashed checks, even though, again, it's not our fault that they didn't, take the check and deposit it to their bank account or take the check to their IRA. I mean, we can't drive to their house and, drive them to the bank, but they just don't like to see those uncashed checks. Also prioritize participants who are approaching or are past the required beginning date, because that's going to create a qualification issue. But the IRS does provide some relief against that if you've made, good faith efforts to try to locate these people. And then, as I said, prioritize the large checks and the large accounts over the small. I'm not saying ignore the small. I'm just saying, like, if you have, if you have a long list and you're trying to prioritize, these are the ones that that should be prioritized. The next and final hot topic that I wanted to cover is cybersecurity. So both of these topics, missing participants and cybersecurity, would not have been part of a presentation that we gave 5 years ago. These are really, new and emerging topics, and cybersecurity is the second of these two topics. There, the incidences of security breaches, I hope I don't have to tell you this, is an increasing threat, sort of no matter where you are or in what context we're talking about. And then last year, the Department of Labor issued a set of best practice guidance that tells fiduciaries, this is what we think you should be doing as a fiduciary to address cybersecurity with respect to participant accounts and benefits. And then finally, we have a number of recent lawsuits that have been brought against plan fiduciaries as well as service providers by plan participants that have been impacted by security breaches and or fraud. So this is newer, and we will be talking about some of those lawsuits in more depth during one of our next webinars. But this is a new, theory and new set of lawsuits that are creeping up. So it definitely should be something that is paid attention to. That DOL best practice guidance that I mentioned includes tips by the Department of Labor that should be used when hiring a service provider. There's a list of cybersecurity 12 best practices that assist both plan fiduciaries and record keepers in meeting their responsibilities to manage cybersecurity risk. And then finally, there's a set of online security tips that are designed to be communicated to plan participants and beneficiaries that are designed to help them ensure, that their accounts are protected against the risk of fraud and loss. I mean, this includes something as basic as, don't share your password. Don't write your password on a, post-it and put it next to your computer kind of thing. But it's kind of a long, comprehensive list of those types of things that are tips for participants and beneficiaries to follow to reduce the chance of a cybersecurity incident. Sharing with you, again, an actual Department of Labor auditor request related to cybersecurity. Again, note that this was sent on August 17th, less than a month ago. They note that they want a response by August 31st. So again, they expect a very short turnaround. And again, even if you ask for and are granted an extension, it's not going to be a lengthy extension. So it's best if you've already addressed these items, or at least most of them, and are able to kind of quickly produce this information. But as you can see, they're going to ask for all sorts of data security policies and procedures that you as a fiduciary and as an employer sponsoring the plan have implemented. Really only one of these items, item H, is targeted and focused on vendors and third parties, and they want to see the agreements that are in place, as well as documentation regarding the third-party service providers' management of cybersecurity risks. So these are things that you want to already have gone through and reviewed and have on file and documented that you've done so, preferably through meeting minutes at a committee meeting.
Mm-hmm. And Laura, just a comment on that is the cybersecurity with respect to the DOL not only applies to 401k plans, it also applies to pension plans and welfare plans. So they're also interested to make sure not only your 401k data and information that you have as a plan sponsor that you transmit back and forth, and payroll data that you have that you transmit back and forth between your vendors. Not only that, they want to make sure that all the welfare plan information you have on your participants in their elections and any medical information that you may have possession of from your vendors, your welfare plan vendors, the Aetna, the Cignas of the world, is also kept and secure. So it's more broad-based, but not just focusing on 401k, they're also focusing on the other areas for which they have jurisdiction. So it's very important to make sure you do have your in-house cybersecurity processes in place. You probably do. You just need to go out. Whoever is internally your cybersecurity IT expert, your head of cybersecurity, can make sure, and I would share them this slide, that prior slide, I would share it with them and say, hey, if we got audited by the DOL tomorrow, can you give us this information? Because it's really not HR or benefits has this. This is your IT cybersecurity team that should have all this readily handy and available. If they don't, that's something that needs to be discussed. Thanks, Laura.
Yep, agree. So real quickly, the checklist of items that you should consider doing: monitor your service providers against the cybersecurity 12 best practices. Many of the large record keepers have very good documentation that's already out there and available that is lined up against these 12 best practices. So if you're with a record keeper of any size, this shouldn't be too difficult of a thing to check off. You want to make sure you're communicating to plan participants those DOL tips. Put them in your SPD. Put them on the website. But you want to show that you've provided those to the participants. You also want to consider multi-factor authentication, and does your record keeper offer that? How many people are using it? If not a lot of people are using it, consider a campaign encouraging people to use it. Maybe even make it automatic. Different record keepers have different policies and procedures around that, but multi-factor authentication can really be a nice, way to reduce cybersecurity incidences or breaches. Evaluate your own internal security processes against the Department of Labor best practices. Review all of your service provider agreements for updated data protection security provisions. Again, a lot of the large ones have already created good contractual language that lines up with the DOL's guidance, and it's just a matter of asking for that and getting the document updated for it. And then finally, a recurring theme, document that you have reviewed all of these items and present it to your fiduciary committee. Provide a report to them. Here's what we've done. Here's what we, have found, and here's how it lines up with the DOL's, best practice guidance. I think with that, we just have 1 minute left. I have been monitoring the questions. There are a lot of, I guess there was an issue with the link to the slides in, the webinar under handouts. We will be sending out the slide deck along with a recording of this presentation. Typically, it'll arrive within 2 business days of the program. It'll be sent to everybody who registered for the program, whether or not they were able to attend. Our next webinar will be October 12th, and we'll address recent ERISA litigation developments. Some of those will touch on some of the concepts that Tim and I covered today. If you have any questions we weren't able to get to, please reach out to your Thompson Hine attorney, or if you're not currently a client, feel free to contact me or Tim, and we'd be happy to try to help, address your questions. But with that, thank you very much, and I hope you enjoy the rest of your day and week.